Hello and welcome to another episode of Legal Wrangle on International Tax. Today we bring you 5 cases, including the recent landmark decision of the Delhi High Court in the case of Sony Ericsson and others. The High Court disagreed in some respects with the special bench decision in the LG Electronics India case and held that the bright line test and segregation of non-routine AMP expenses has no legislative backing. Other decisions in this episode of Legal Wrangle deal with unexplained funds of NRIs, arm's length interest on loan given to foreign subsidiary, and whether legal expenditure incurred on foreign attorneys in connection with a company takeover are they capital in nature? But let's start with our key case.
The assessees are Indian subsidiaries of multinational companies. The assessees are Sony Ericsson Mobile Communications India, Canon India, Reebok India, Hair Appliances India, Daikin Air Conditioning, Casio India and many more.
The question of law related to advertising and marketing promotion expenses incurred by the assessee in India for promoting a foreign brand is an oft-recurring issue. Courts have generally followed the landmark decision in the case of LG Electronics India, wherein the tribunal by a majority decision had held that the bright line test using comparables may be applied to segregate the AMP expenses incurred by the assessee for its own business vis-a-vis promoting the brand value of its foreign associated enterprise for owning the brand. The tribunal also held that the bright line test does not require any statutory endorsement. But now, following the decision of the Delhi High Court, the bright line test is held to be against the spirit of Chapter 10. The Delhi High Court also held that selling expenses, including trade and volume discounts given by the assessee, cannot be included in the AMP expenses. Let's go to Maneet for the facts of the case.
The assessees were Indian subsidiaries of MNCs and engaged in distribution and marketing of imported and branded consumer goods, manufactured and sold to them by the foreign AEs. In some cases, products were manufactured by the Indian subsidiary under license in India. The intangible rights in the brand name or trademark was owned by the foreign company. The assessees had incurred AMP expenses in India. Some assessees had received financial support from the AE in the form of discounts and reduction in the sales price, while some assessees had offered volume discounts to their dealers. In the transfer pricing report provided under Section 92E, the assessees' international transactions included the AMP expenses incurred in India. The assessees had also claimed the AMP expenses as deduction under Section 37. The TPO concluded that the bright line test was an acknowledged and accepted tool to determine routine and non-routine AMP expenses. The TPO thus bifurcated the assessee's AMP expenses into marketing or sale promotions and brand building by adopting the bright line test.
The tribunal, following the majority decision in the case of LG Electronics India, upheld the validity of the bright line test and decided the legal grounds in favor of revenue. However, the tribunal also held that sales-related expenses in the nature of trade and volume discounts and rebates paid by the assessee to dealers could not be included in the advertising and marketing promotion expenses. The matter went up before the High Court, which dealt with various key issues.
The Delhi High Court ruled on the application of the bright line test as laid out in the LG India decision, that is, the segregation of distribution and marketing expenses for determination of arm's length price, allowability of AMP expenses as business deduction, and difference between brand creation and brand building.
The Delhi High Court held in favor of the revenue that AMP expenses are international transactions under Section 92B. The foreign AE must compensate the Indian assessee for advertising and marketing promotion expenses, which may include a lower purchase price or even reduced royalty. The court pointed out that the department did not question the expenditure paid by the assessee to third parties, but was questioning the adequacy of the compensation from its AE. It upheld the TPO's jurisdiction in making the additions by holding that after the retrospective amendment to Section 92 CA, no specific reference was required. However, on certain key issues, the court disagreed with the legal ratio in the majority decision in LG Electronics India, holding that it was erroneous and unacceptable.
The Delhi High Court disagreed with the majority decision in LG India by holding that it laid down parameters for selection of comparables, which amounted to prescribing a mandatory procedure not stipulated in the IT Act or rules. It was unwarranted and amounted to judicial legislation.
The Delhi High Court also pointed out why the bright line test could not be applied to international advertising and marketing promotion transactions.
The court concluded that the application of the bright line test was not mandated in the Act or the rules. It held that Indian companies owning brands could not be treated as comparables with assessees who were not legal owners of the brand. Also, the application of the bright line test to Indian companies owning brands could result in tax complications.
The Delhi High Court also ruled that for the determination of arm's length price, AMP expenses could not be segregated from the composite transaction, including distributing and marketing expenses.
The court held that revenue could consider segregation of distribution and marketing functions to compute the arm's length price only after providing justification and reasons.
The Delhi High Court held that AMP expenses were allowable as a business deduction, but its allowability would not curtail the operation of Chapter 10 on transfer pricing.
Allowability of AMP expenses as business deduction would not curtail impact of Chapter 10.
The Delhi High Court also deliberated extensively on the difference between brand creation and brand building, observing that product promotion could not be compartmentalized and separated from brand promotion.
The Delhi High Court held that routine or day-to-day marketing or sales promotion expenses, even when excessive and exorbitant, would not amount per se to brand building expenses.
This is no doubt a landmark decision from the Delhi High Court with several key takeaways.
AMP expenses are international transactions allowable as business deduction and will not curtail impact of Chapter 10. Bifurcation of AMP expenses is unwarranted. AMP function is closely linked with marketing and distribution expenses and cannot be segregated from the composite transaction. Selling expenses are not part of AMP expenses. The T&M method is reliable and preferred method for determination of ALP.
The Delhi High Court thus remanded the case to the tribunal to examine and ascertain facts and apply the ratio as enunciated. This decision may certainly bring relief to Indian subsidiaries. Will it apply to the pending cases? Only time will tell. Our next case revolves around a non-resident Indian who brought in loads of money into India from his own overseas account.
The assessee is a NRI and the chairman of Hyderabad-based company MS Lanco Infratech Ltd.
The interesting question in this case was, when foreign remittance has been received in India from the NRI's own overseas account, can revenue question the source of such funds and label it as the assessee's unexplained income under section 68 and 69? Let's go to Maneet for the facts of the case.
The assessee had various investments in India and had shown receipt of huge remittances from his own bank account in Mauritius into his Indian NRI account. The assessee explained that he had received a loan from a Mauritian company in which he was the sole shareholder. The assessing officer held that the Mauritian company was nothing but an alter ego of the assessee, and even if the funds were proved to have been transferred from the Mauritian company to the assessee's bank account in Mauritius, it still did not explain the source of these funds. The AO thus treated these funds as the income of the assessee under section 68 and 69.
The tribunal dismissed the revenue's appeal, holding that there was no evidence against the assessee that these funds received into his Mauritius bank account was his own income from India on a round trip. Such inward remittance cannot be considered as the unaccounted income of the assessee.
The tribunal held that money was received from the assessee's own bank account overseas and no income could be said to have accrued or arisen in India. The assessee had proved the source of funds and discharged the owners. There was no question of any investment or unexplained credit. The revenue had failed to prove that the remittance was the unexplained income of assessee.
Well, it is clear that bringing up the evidence for source of funds in the case of an NRI can be rather tricky. In our next case, the assessee is Cyient Ltd, formerly known as Infratech Enterprises.
The assessee company is in the business of software development.
An interesting question which came up in this case was whether legal fees paid to foreign attorneys in connection with takeover of a company, would it be the capital expense or deductible as revenue expenditure? Let's turn to Maneet for the facts.
The assessee had paid legal fees to foreign attorneys for services rendered in connection with the acquisition of an American company. No tax was deducted at source on this payment as the attorneys were based in America and did not have any fixed base in India. The takeover proposal, however, did not work out and the assessee claimed the legal fees as a business expense. The assessing officer held that the payment of legal fees was incurred in connection with the acquisition of a company, a capital asset, and it was a capital expenditure. The AO also took the view that as tax was not deducted at source, the payment to non-residents was disallowable under Section 40, even if it were considered as a revenue expenditure.
The tribunal held in favor of the assessee that the legal fees paid to non-resident were not taxable in India and hence no tax deduction at source was deductible on the payment. Also, it was revenue expense as the takeover proposal did not work out.
The tribunal held in favor of the assessee that the legal fees paid to non-resident in connection with takeover of a company was revenue expenditure, as no asset of enduring benefit was acquired by the assessee. The payment was not taxable in India as non-resident had no PE in India.
Well, the purpose for payment of legal fees is an important point of distinction. Our next case relates to taxability of advertisement and subscription revenues for a foreign telecasting company.
The assessee is Animal Planet, a non-resident company incorporated in Delaware, USA. It is the business of broadcasting the channel Animal Planet in Asia region, including India.
The tribunal considered the question whether the resolution for levy of a lower rate of tax under the mutual agreement procedure invoked by a group company of the Assessee under Section 27 of the India-USA DTAA for an earlier assessment year could be extended to the Assessee. Under the tax treaty, a resolution passed under the mutual agreement procedure is applicable only to the entity invoking the same and for the specific assessment year covered by the resolution. Let's go to Maneet for the facts.
The Assessee had appointed an Indian company, Discovery Communications, as its exclusive advertising sales representative in India for marketing the channel and paid commission at 15% of the sales revenue. Under another agreement, the Assessee had granted Discovery Communications India distribution rights for the channel. The Indian company incurred the necessary costs for channel promotion and received the entire subscription income which were duly offered to tax in its own return of income. The assessing officer held that the Assessee was not eligible for treaty benefit as the Indian company constituted the dependent agent PE of the Assessee in India. The AO thus treated the advertisement revenue as the Assessee's taxable income and subscription revenue earned by the Indian company as the royalty income of the Assessee.
The tribunal considered that earlier a group company of the Assessee had invoked Article 27 of the India-USA DTAA, and under a mutual agreement procedure, competent authorities in India and USA had agreed that 10% of distribution and advertisement revenues earned from India should be taxable in India, being the profits attributable to the dependent agent PE in India. The question was whether this resolution could be applied in the case of the Assessee.
The tribunal considered that revenue had completed proceedings for previous assessment year on the basis of MAP resolution of the group company. It was essential to ensure consistency of assessment when facts remained the same. Hence, the lower rate of tax at 10% was applicable.
Well, consistency of assessment won the day for the Assessee. Let's move on to the last case of this episode, which relates to the arm's length rate of interest charged by the Assessee from its foreign subsidiary.
The Assessee is an Indian company in the manufacture and export of rider apparel or clothes for horse riding.
The Delhi High Court ruled on the question whether the 4% rate of interest charged by the Assessee on the foreign exchange loan given to its overseas subsidiary was at arm's length, as held by the tribunal following its earlier order. Let's turn to Maneet.
The Assessee had a presence in several countries through various channel partners and distributors. However, for promoting its exports to America, the Assessee set up its own wholly owned marketing subsidiary in USA. To meet its working capital requirements, the Assessee had provided a foreign exchange loan in Great Britain pounds to this subsidiary, granted under agreements which fixed the rate of interest at 4% on the principal amount. In its transfer pricing report, the Assessee declared that this 4% rate of interest was at arm's length as it was comparable with the export packing credit rate obtained from independent banks in India. The transfer pricing officer considered the average 6-month GBP LIBOR rate to determine the cup rate for charging interest. He held that the arm's length interest rate should be taken as 14% per annum. A transfer pricing adjustment was thus made against the Assessee. The DRP granted the assessee partial relief by reducing the interest rate to 12.2%.
The tribunal considered that even though the assessee had a loan arrangement with Citibank for interest less than 4%, it had charged 4% from its AE. The tribunal thus held in favor of the assessee by following its earlier order in the assessee's own case. The case went up to the Delhi High Court, which held in favor of the assessee.
The Delhi High Court held that the currency in which the loan is to be repaid determines the rate of return of the money lent. The loan granted overseas was not being repaid in Indian rupees. Hence, the TPO's reasoning was illogical. Also, when the same interest rate of 4% was accepted in earlier assessment years and in subsequent year, it had to be accepted to be at arm's length in the current year too.
Well, that brings us to the end of this episode of Legal Wrangle on International Tax. You may write in to us at editor@tioltube.com. Please do subscribe to the TIOL Tube channel on YouTube. Keep calm and have a nice day.